car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch, Monday through Thursday from 10 a.m. till 3.
Everybody ready?
Yes, Your Honor.
Yes, Your Honor.
We are back on the record, 21 CF 2144, State of Florida versus Ronald Norris. We've taken a recess for about 3.5 hours, during which time I watched about a 3-hour and 20-minute video. Sorry, we had to start a little bit late just so I can get through the entire thing in order to review all evidence before we get to this point. Ms. Sandler, any other evidence from the state?
No other evidence from the state, Your Honor.
Mr. Williams, you stated that you wanted to potentially call a witness. First of all, any argument as to whether or not they have the ability to do this, Ms. Sandler? I know you brought it up before, so I'd just like to get going on that.
I think at this point it's two-pronged, and one was whether or not they can present a rebuttal case, and I think the second is whether or not he would be able to present this witness as a prior inconsistent statement of Ms. Smith. Now, the state's position for a rebuttal is that they are not entitled to a rebuttal case, but there's no authority on that. The closest authority that the state can really get to, Your Honor, is just that once the defendant raises a prima facie claim of immunity, they bear no further burden. I think that's about the closest we get on the case law. So, of course, that would be left up to the state on that issue. But I believe that is the defense's only witness. So the second prong of that particular witness is that his proffered testimony is expected to be that Ms. Smith made a statement that's inconsistent with the defense's theory, but the defense did not lay the proper predicate. Now, the state did some research over the break, too, with Earhart's, and also looked up notes of decisions on that particular statute, the Bible of evidence here, Your Honor, and 90.614 of the Florida statutes governs the prior statements of witnesses and prior inconsistent statements specifically. The notes of decisions go all the way back to 1887 that the state could find, and the law has remained remarkably clear, especially in the first DCA, that the defendant here must lay a proper foundation for the prior inconsistent statement. The defense admits that they did not do so, and the state's recollection and watching the cross-examination of Ms. Smith yesterday, the state did not find any mention of that prior inconsistent statement. So because the defense admits he did not lay the foundation for that extrinsic evidence of a prior inconsistent statement, that statement is not admissible at this time. That could be fixed in trial if we even get to that point, but the impeachment must be done while the witness is on the stand.
Judge, the only thing that I did pull the cases on it, most of them have to do with the situation where you're impeaching with a writing, a deposition, a signed statement. The state's, what I had, but it does appear that the gravamen of it is I've got to give the witness an opportunity to admit making the statement or to explain making the statement before I can introduce the statement. That, I admit, did not happen on cross. My intention was to simply have the gentleman come in and testify what she had told him about how the shooting actually occurred, and then the state would have an opportunity to call her or to ask her, if she said that, give her a chance to deny it, cross him on it, things of that nature. I had raised the issue. I know that Ms. Smith has been out and about the hallways today, perhaps as part of my case, calling her, and the state, their theory is that would be calling her for the purpose of impeachment. My response would be that I'm calling her.
Those two sections are right next to each other in all the books.
I'm calling her to establish the predicate. I'm not calling her so that I can elicit further information out of her and then impeach her with it. But I admit that it's a very close call on it, and I may just have to fix it in trial the way that, and in fact, Ms. Sandler and I discussed this earlier, if we get to the point that there's a trial. All
right, well, in my research and looking over the things, I I've looked through my Earhart book and my Earhart trial objection book. I mean, they're obviously part and parcel together, and it usually gets us quickly to the point. It's not about it's the only thing that matters, but it certainly gets us there more quickly, and certainly finding these issues. But Florida Statute 90.614, paragraph 2 says, extrinsic evidence of a prior inconsistent statement by a witness is inadmissible unless the witness is first afforded an opportunity to explain or deny the prior statement and the opposing parties afforded an opportunity to interrogate the witness on it. So just what we mean by extrinsic evidence is evidence other than the actual statement. So the writing, the witness who's going to come in and say, that's not what, this is what I heard the witness say. So until there's the witness is given the opportunity to basically admit or deny or explain the particular statement that's going to be testified to or brought as evidence, as extrinsic evidence, the foundation hasn't been laid. What I'd like to make sure we get to a point of is, Mr. Williams, do you want a ruling as to whether or not you have the right to have a kind of a rebuttal case here? Do you want to make any argument for that?
Judge, neither the state nor I could find anything definitive. I did find a couple of cases that discussed the state's rebuttal case, which implies that there was some sort of defense case between the states, because the burden is shifted. It's almost like a new hearing. Between the state presenting, attempting to prove by clear and convincing evidence that the defendant did not actually believe he was in danger or did not reasonably believe he was in danger. So that implies that there would be a defense case somewhere in there. So I just to keep it alive for later purposes and for appellate purposes, I think that there would be an opportunity for the defense to put on a rebuttal case, but there is nothing clear on this. We are and establishing new ground, and this may be an issue where the legislature should have been more complete about procedures, and simply was not. To me, it seems to make no sense and to have due process problems if the defense cannot respond to the state's presentation of evidence. Now, it is a situation where it's not like a motion for judgment of acquittal. The court is not only not instructed, but I would argue not allowed to resolve all inferences in favor of the state. The burden is to prove by clear and convincing evidence, and I'll talk about that more in my closing. But at this point, I watched the video and watched it again over the break as the court did. I don't think that there's any reason or need for me to put my client back on the stand for another 3 hours of testimony to go over the same stuff that's either evident in his original presentation or on the video. And again, I'll address that more in closing.
The only thing you're asking to do is put on testimony of impeachment of a witness that was brought on by the state.
That's correct, Judge.
Okay. Obviously, I wish there was something more telling as to what the court's allowed to listen to or what the defense can present. I guess the way I look at it is it seems, I don't want to give a factual scenario because someone might determine that's what I think is going on in this particular case. But for example, if in one of these types of hearings the state puts on a witness that has, say, prior record of felony convictions or crimes of dishonesty, and that witness were to deny those things ever happened, the only way for the defense to truly impeach them would to put on extrinsic evidence, put on actual evidence of those convictions or something like that. Same thing here. If you've got a witness who said something and someone else maybe say the opposite, or that witness had said something different, inconsistent with that previously, and that person denies it, that shouldn't the defense have an opportunity to put on that extrinsic evidence during a kind of a rebuttal to impeach that person, because they can't really do that during the course of the witness's own testimony. So I would think it's at least as far as pure impeachment purposes that the defense should be allowed to do that. However, in this particular case, I don't think the proper predicate was laid. Ms. Smith, who is really the eyewitness to what this case is all about, was never asked any questions about, did she ever make any statements to anybody about it. She never was given an opportunity to explain those things as to what she may have said and to who and at what time. I think she has to be basically confronted with, did you at this time, at this place, to this person, say, these things, and that simply wasn't brought up. So since there hasn't been a proper foundation laid for that impeachment, I'm not going to allow her, the other witness, to come in at this point. Obviously, if there's anything else you want to put on the record, Mr. Williams, you're free to do so at this time.
Just that I would not be allowed to call her for the purposes of asking her those questions. That I cannot call her now for that purpose.
Does the state want to be heard on that part? I mean, is she even available?
She is here, but he would just be calling her for the purpose to impeach her, which is not proper.
Okay. Mr. Williams, do you want to make any more argument on that?
Judge, just what I'd said before, I'm trying to establish a predicate. I'm not actually calling her for the purpose of impeaching her. I'm calling her for the purpose of establishing that she had this communication and give her the opportunity to respond. The impeachment would actually come from the witness that I would call.
And, Your Honor, just to make it clear, that's something he should have done on cross. And if the tables were turned, he would be asking the state not be allowed to ask questions simply because the state forgot to do it. So I think at this point, he should not be allowed to call Ms. Smith for the purpose of laying a predicate to impeach her, because the whole purpose is impeachment. The sole purpose of calling her is to impeach her.
So I'm looking at Morton versus State, which is cited in the Earhart section on this particular topic, which is a Florida Supreme Court case from 1997, 689 Southern 2nd 259. I've looked at it. I believe there was some negative history on it, but it's really on a different issue. But it specifically says, and I think this is important, obviously, no single rule can be delineated to cover all of the circumstances under which parties will seek to impeach their own witnesses. Generally, however, if a party knowingly calls a witness for the primary purpose of introducing a prior statement which otherwise would be inadmissible, impeachment should ordinarily be excluded. On the other hand, a party may always impeach its witness if the witness gives affirmatively harmful testimony. In a case where a witness gives both favorable and unfavorable testimony, the party calling the witness should usually be permitted to impeach the witness, with a prior inconsistent statement. Of course, the statement should be truly inconsistent, and caution should be exercised in permitting impeachment of a witness who has given favorable testimony but simply fails to recall every detail unless the witness appears to be fabricating. In addressing these issues, trial judges must have broad discretion in determining whether the probative value of the evidence is substantially outweighed by the danger of unfair prejudice or confusion. So basically kind of a 403 analysis at the end there. It sounds like the only reason why she'd be called as a witness is to say, hey, didn't you say something different before? Which I think at that point is calling a witness simply to impeach that witness. And as the Morton case talks about, is just to introduce a prior statement that's inconsistent with her testimony. So on that basis, I'm going to go ahead and deny the defendant's request to have this witness and have Ms. Smith take the stand just for this simple purpose of then coming back and saying, well, didn't you say something different? Didn't you? And you're impeaching your own witness, and that is the only reason why you're calling her. Obviously, if Mr. Williams, you need to put anything else in the record, you certainly can. Otherwise, we're going to proceed with the next step.
Understood, Your Honor.
Okay. Anything else that you want to present, Mr. Williams, other than argument?
No, Your Honor, just argument.
Okay. All right. Ms. Sandler, I guess, Mr. Williams, we talked a little bit this morning about how y'all want to go forward with arguments. Are y'all prepared to do that today?
The state is prepared to do that, Your Honor.
We can do that, Judge.
Okay. All right. Do you need any more time, Mr. Williams or Mr. Norris? Do you need any more time to discuss with your lawyer before we finish up with closing arguments today?
You need to have further conversations with me for any reason before closing?
Okay. Just want to make sure. All right, Ms. Sandler, I'll have you go first since it's your burden to prove by clear and convincing evidence that immunity is he's not entitled to immunity in this particular set of circumstances. And again, just to make sure everyone's under the same idea, I don't expect to rule from the bench here. Obviously, we had a day's worth of testimony last week. I want to go back and review that as well as review the somewhat limited case law authority regarding this particular issue since its amendments recently. And then I will issue a written ruling. I know we had talked a little bit about potential written briefs regarding this issue. It sounds like y'all don't want to do that at this point, so that should certainly speed up the process, and I'm not waiting for the brief before I make an order.
Judge, I can go either way on it.
Okay. Well, I'm flexible. I want y'all to have all the opportunity you want to be able to explain what you want to explain, whether that's...
The only thing I would ask is if we do written, the court set a date by which the state's initial would be served on me, then give me X number of days to give my written argument.
Let me just make sure I'm clear, Mr. Williams. I'm not requiring any sort of writing.
No, I understand, Judge. I'm just saying if we are going to do it that way, the state had raised that issue earlier. I'm fine with it. Let's just set time frames.
Ms. Sandler, are you requesting to give any sort of written argument?
I mean, Your Honor, given the fact that this is a novel area of the law, I would be remiss as the state to say I'm okay closing without a copy of the transcript, without the ability to compare the transcript to what limited applicable case law we have. The state does have a PowerPoint, and the state is prepared to close today. Ultimately, it's the court's decision what we do. It would certainly speed up to be able to close today, but would it potentially create an appellate issue for us not to be able to brief? It potentially could.
That's why I'm asking if anyone is requesting it.
Judge, my understanding earlier today was that the state was requesting it. I was in favor of it and still am. She raises some valuable points that work well for both sides, but I'm here to serve.
Well, here's the way I look at it. I'm willing to let y'all do whatever it is that you're requesting to do. If you want to do a written argument, do a written argument. If you'd rather just give a kind of an oral closing argument, you can do that. And I don't say this in a way that I'm trying to encourage or discourage anything, but ultimately, if there's going to be writing, especially if either side wants a transcript of this in order to kind of be as detailed as possible in their written brief. Those things take time. As I've talked about, this case is almost 3.5 years old. I'd like to get it resolved one way or the other through the next trial cycle, which is basically March would be the next trial calendar. I certainly want to give you all the time to do what you want, but as long as you're giving me enough time to then get the work done.
Yes.
I also don't want it to be a situation where it's the eve of trial that, we're trying to figure this out still. It's kind of the problem that we've run up against this week, is finishing this up today and not having really sufficient time to try the case next week on a short week. So I'm fine with the written arguments as long as we can get them back relatively quickly. But if you want a transcript, I can't tell you how long that's going to take.
I think we can probably rush a transcript. See any reason why
Okay.
this particular.
And we can just share the file, and that will save both sides some expense. So how long you figure?
Or a way maybe that we can give our oral closings today with leave to file a supplemental brief to the court by a date certain without doing the response to this and response to that we both, with what we have.
Well, the state would file a brief, and then there's a reply and a response, and
and
I'd rather not.
and ad nauseum, I think if we can both just have the opportunity to supplement the record with a supplemental brief, and that way we're each giving the court a supplemental brief to our closing rather than doing a briefing of the closings, and I hope that makes sense.
I would object to that. What I foresee happening is one or both of us filing a written argument, and then the other side not being able to respond to it because it's filed at the 11th hour. If we're going to do written arguments, I think that, and the state gets first and last, which is how I see it as well. It was their burden. Then the state would file its written argument. I would get their argument, respond to it with my written argument, and then the state would file its response, its rebuttal, and that would be it. Just like if we were doing oral arguments at a trial. I don't see the add-on infinitum thing, and I don't see both of us filing at the same time as being a fair or effective way to do this. Now, I realize that means the state gets the last word, but that's what's going to happen in oral argument anyway. The state's going to get the last word.
I tend to go his way, Ms. Sandler. I mean, it doesn't mean your reply brief has to be, another tome. It's really up to you if you even do a reply brief. But what I'll do is, if y'all want to give kind of an oral closing supplemental briefs, I'd like to have those. Probably we can come up with a calendar for it, but I just don't know as far as the transcript is my only real concern as to how fast y'all get that. And frankly, I don't want to put it necessarily into a time where we're back into the next part of a cycle and everyone's back in court every day, like for the past 2 weeks like we've been, where you don't have the time to get things done, and then the court doesn't have time to timely rule, because again, I don't want this to be a situation where we're in the next trial cycle and still trying to figure this out. I'd like to certainly have it done before that February 24th date. So
And the state believes that as long as the state doesn't pick up a trial next week in Judge Stone's division, the state could probably have their first brief done if we can get the transcript back in time.
So that would be the 24th? Okay.
If we can't, we would, of course, let the court know the transcript was not ready, but.
All right. And how much time would you need after you receive theirs, Mr.?
Judge, what I was going to ask for was 10 days.
Okay. Why don't we do this? January 24th, close of business for the state's brief. That's next Friday. Obviously, if something comes up, Ms. Sandler, you end up with a trial that takes up a bunch of your time, or the transcript can't be done in a timely fashion, I'll certainly entertain a request for an extension of time. Mr. Williams, I'll give you 10 days to reply once you've received it. I'm not going to give a hard date on that yet until we know that she's filed it. Obviously, if you need an extension, you can certainly ask for it, but 10 days from that puts us about 10 days from our next pretrial. So I want to make sure I've got the adequate time to respond, and then what I'll give is from the time that you receive his reply, or I'm sorry, his reply brief. If you want to respond, you can have 5 days from that point. Otherwise, I got to get to my work. And I want to make sure I'm reading everything. I'm sure I'll be doing some research and review of the evidence before I even get your briefs, just so I can be prepared to hit the ground running once I do.
Yes, sir.
All right. Given that, you still want to go forward with the closing arguments today, correct?
Judge, I'm fine with, again, I'm fine with whatever.
All right, Ms. Sandler.
I would defer to the court. I have a PowerPoint that I made yesterday to point out some evidentiary issues.
All right.
Of the law for the brief.
I think that could certainly help, again, in getting things done in a timely fashion. If I could see what y'all's arguments are, at least the coming attraction of what your brief is going to be, at least will tell me where I'm at. It's obviously kind of the opposite of what we deal with in an appeal, is we read the briefs and then we watch the argument, or have the argument, but this will be kind of a little bit in the reverse, but I think it will help me as to kind of shaping my research as well, so I know what y'all are coming up with.
Yes, sir.
It's a teaser trailer for our brief.
Okay. All right. Yes. All right, Ms. Sandler.
And, Your Honor, I do have a PowerPoint. If you pull that up, it is plugged in. If it is available for...
It should be once he pulls it up. It's not visible right this second.
Is it visible now, Mr. Williams?
Not yet. It was up before, so I think the monitor is on. I haven't,
That should do.
touched, there we go.
Okay.
It's up now.
All right, I've got it here on the screen in front of me.
Perfect. So for the record, Your Honor, the theme here for the state is vengeance, not fear. The state believes that at that point in time, Mr. Norris was vengeful and not fearful. The state asked the court to pay careful attention to the section of the interview where he said he had the gun for his fear factor and he wanted them out, not that he was scared. Now, the defense, we anticipate, will say he wanted them out because he was scared, but this is a domestic dispute. And most notably, this was a domestic dispute between Tracy Smith and Ronald Norris, not a domestic dispute between Joseph McCombs and Ronald Norris. Now, this is a rapidly developing area of the law. This is new, and it's obviously taking time for things to get through the appeals process and then trickle down to where we have a body of law of prongs and standards to follow. But we ask the court to look at the law and look at the evidence as it applies to the law and find that the state has met their burden by presenting evidence. What we want to point out from an evidentiary standpoint to the court is the fact that when there was that first call out after Mr. Norris got back from the hospital, the court can clearly see from these still photographs from the body cam video that the porch was not in the shape that it was in. The crime scene was called out. There's some stuff on the porch, but it is definitively not in the same shape. The curtain is up. There's not a whole lot on the table, and that china hutch is absolutely in one piece. When you get to the crime scene, and it's completely uncontroverted that Ms. Smith did not come into the trailer that day between that time of the first call out and the time the event occurred. She was not there. You can see where the window has been, I'm going to use the term vandalized. The curtain's been pulled down. The china hutch has been destroyed. Items have been strewn about. And then the porch is in a completely different, things have been thrown out there. Ms. Smith testified that it was hair dye and bleach, but the court can obviously see that's not really the issue. It's covered in something. And the state proffers that what happened is law enforcement came out and told Mr. Norris, well, a wife can't vandalize her own home. A wife can't vandalize her own home. A husband can't vandalize his own home either. So I'll show you. This is what he did. And those are her items on the porch. That's her stuff that's broken. And this is payback for her having him Baker acted. This is not solely from them opening the door. The porch would not be from them opening. And this is also why it makes sense that she would come back into the house to retrieve her clothes before he could destroy more of her items. Now, the undisputed facts are that Tracy Smith had Ronald Norris put under the Baker Act, and he was upset about that. He was very, very angry. The undisputed facts are that Joe McCombs never threatened Ronald Norris by word. The undisputed facts are that Joe McCombs never threatened Ronald Norris by act. Joe McCombs was unarmed. Ronald Norris knew who Joe McCombs was, and that Tracy Smith never entered the home after he got back from the hospital until this incident. State has to point out that Mr. Norris's version of events on the stand was completely different than his version of events in his interview with Investigator Padilla and Investigator Kruger, to the point of completely different hands grabbing the gun. He swore it was a left hand that grabbed the gun in his interview, swore it was his right hand while he was on the stand. Two very different things. In his testimony on the stand, he showed the court how he was holding the gun, and that is extremely consistent with the wounds that we saw on Mr. McCombs, having the gun held like that. State is going to mark the inconsistencies in their brief, but the inconsistencies are very numerous. Was it his right hand or his left hand? How did things occur? Did he see Joe McCombs come in? Did Joe McCombs come in through the door a certain way? And what the state wants the court to take note of is the fact that the door swings outward and not inward. So Joe McCombs would have come through a perfectly open, because the door swings all the way out. It doesn't swing in where you can hide behind it or kind of shoulder your way in or look around it. It's an outward door. So once the door is open, you just come in through an open door. Ronald Norris also told Todd Padilla he wasn't scared of Tracy Smith. He told Todd Padilla the gun was his fear factor. And this is where it creates the aggravated assault, Your Honor. Because he told Todd Padilla he brandished the firearm. That is the word he used, brandish. He was very careful on the stand. Oh, that's not brandishing. When you hold a gun up and I point it in someone's face, it's not brandishing. That's brandishing a firearm. And by the plain statute of aggravated assault, that's what it is. And then we get to the evidence given by the medical examiner, who has no skin in this game. And this is where the case law, and we'll talk about it in our brief more, is very clear that the court needs only competent and substantial evidence for the state to show by clear and convincing evidence and the state to have met their burden. And the court is the finder of fact in this particular hearing. So the court can determine who's credible, who's not, what the court believes, what the court doesn't, who has the most to gain, the same way a jury does. But there is case law that says, and that's Swift v. State, and we'll cite it in our brief, from the first DCA in 2022, that states that the court can look merely to the inconsistencies, and that is competent and substantial evidence that the court can find by clear and convincing, even though the burden's different than the quantum, that the defendant is not entitled to immunity. And the medical examiner testified that this wound, the intermediate distance, that it's got the classic signs of intermediate distance. The scalloping on the edges of the wound, at least 3 feet, but she says over because of the lack of wadding in the wound. And Christy Hoffman testified that the wadding was found in the kitchen. and bullet wipe versus the tattooing of gunpowder and soot. And she was very specific that the tattooing stays. And that is why the bullet wipe is so different, because she was able to just wipe that off the bone. And that's just from shot going in. She also mentioned the lack of tattooing and soot on the skin on the inside. Now the court can see, and the court has the benefit of the exhibits, that there are marks on there from where the shot has spread, and that's also very important. The lack of tattooing, the lack of soot, the lack of anything that shows that it's a close contact wound, because there is the spread of the shot, and that only happens after distance. And the hat has shot on it, and that's why the state admitted that, Your Honor. So that shows some spread of the shot, rather than what the defense mentioned, the stellate appearance. It's an intermediate distance wound. The wound on the finger becomes extremely important, because that wound is on his right hand. So if his sworn testimony on the stand is to be believed, he grabbed the gun with his right hand. Well, if he grabs the gun with his right hand, how does he get a spread shot wound on his finger? He wouldn't. It's not possible. If it ricocheted, that would be from bullet spread from an intermediate distance. So either way, it's from far away. It's not, and when I say far away, I mean intermediate distance rather than the close up that the defense puts forth. There was no testimony that there were burns or blisters or anything on his hands. And that gets me to the basic rules of force. We don't need an expert to tell us how force works, pushing backwards or pushing forwards. But he says that he was pulling on the weapon such that his finger or his thumb, and we need a transcript to be absolutely certain, pulled on the trigger and shot Mr. McCombs while he was pulling the gun up to his own face. And in his interview, he says, well, I don't understand why anyone would pull a gun up to their face. But if he's pulling a gun up to his face, he is moving backwards. So if that gun goes off in his face, moving backwards, he's going to fall backwards. That's not what happens here. He falls forwards, and he has a wound on his finger that shows that he could possibly have been putting his hand up in a defensive posture when you take into account the spread of the shot.
Your Honor, if I may, I am going to tender an objection, arguing facts not in evidence, at least the conclusion. No expert testified as to what the results of the gunshot and where he should have fallen. The ME was not classified as a reconstructionist and would not have been able to testify to that. I feel like I'm going through the Zapruder film again on whether it should be back and to the left.
The ME actually did testify and use the demonstrative that we had to kind of show which direction she would expect Mr. McCombs to fall.
Court will rely on its own memory and review of the evidence once we get the briefs and reviewed it again. But your objection is noted, Mr. Williams.
Thank you, Judge.
State will brief on whether or not the court should consider hearsay, Your Honor. But what we would note is that anybody can get on the stand and say anything when it comes to an immunity. And that's the problem we have with stand your ground. The state did mention the show from the 1990s, South Park. But it's so applicable in this case because anyone can get up on the stand and say, well, I was scared. He was coming right for me, so I was scared. But that's a bare assertion, and the state will talk more about that in their brief, that a bare assertion is not enough to establish that fear of imminent death or great bodily harm. It's not a speculative fear. It is a fear on a reasonable person objective standard, not a subjective standard, an objective standard. And I think that's where the courts are moving, is to make sure that the evidence meets these objective standards, because anybody can get up there and say, I was scared. But we have to say, would a reasonable person, reasonable and prudent person in the same or similar situation act in the same way? So what the court has to determine is, would somebody in an argument with their wife when their wife comes in to get her things, who knows it's his wife, and knows that it's, even though he said he didn't know, knows who the other person is, and the other person has not said a word to make a threat, and the other person has not done anything to affirmatively show that there's a threat of imminent death or great bodily harm. This is not speculative. This is objectively reasonable. Would they get to shoot another person? And the answer is no. Bare assertion of fear is not enough. And what the state has to point out, and again, these are things we'll talk again in our brief, is the peculiarity of a defendant's mental state is not germane to the issue. And this is something that there is a circuit split. It's currently being reviewed by the Florida Supreme Court, is what he knew about something that somebody told him, that's not really germane to the issue. Would an objectively reasonable person in the same or similar circumstances do the same thing? Misperception, subjective thoughts are not the standard here. Now, what a jury wants to do in a jury trial, they can believe anything they want, but the court looks at that objective standard. The state has to point out, objectively, the testimony today from Victoria Kipker, I can get a full profile out of a small amount of blood. And my blood test is even more sensitive than my DNA test. Both of the swabs taken from that gun, neither showed any blood. That blood test did not react at all. And she was unable to pull out a full profile. She couldn't do that. So if there's a close-up shotgun wound, if this is pulled towards somebody's face and this is close to their face, and we have pictures that we put into evidence that shows the incredible spray, the brain matter, the blood, it's graphic, but that's what happened. And there's not any DNA on that shotgun from Joseph McCombs. His handprint, his fingerprints, they are not on the end of that barrel. What is on there is Mr. Norris's DNA, and that's to be expected. So putting all of the facts together, Your Honor, the state has shown with competent and substantial evidence that meets our burden of clear and convincing evidence that Mr. Norris is not entitled to immunity.
All right, Mr. Williams.
Thank you, Judge. The state misstates the law. It's both subjective and objective. In order to successfully argue stand your ground, a defendant has to show that a reasonable person would have been in fear, but they also have to show that they were in fear. So the question becomes first, were they in fear? And then, was that fear reasonable? So let's talk about what we've got here. First of all, let's talk a little bit more about the law and the standard here. This is not a situation where the court is using the same standard as for a judgment of acquittal. The court is not required to resolve doubts in favor of the state as long as there is some evidence. The court has to weigh the evidence and make a determination whether or not the state has essentially disproven stand your ground or disproven self-defense by clear and convincing evidence. Now, that's not preponderance. That's not the evidence that would be used in a multi-million-dollar lawsuit. It's also not beyond a reasonable doubt. That's the evidence or the standard that the jury will have to use in trial, but it's not in the middle between the two of them either. It's much closer to beyond a reasonable doubt. Look at what clear and convincing is used for. Clear and convincing is used in injunction cases, domestic violence injunction cases. You're going to tell a man that he can't see his kids. You're going to tell him that he can't go back home. It's used in Jimmy Rice cases. You're going to take someone who is finishing their sentence on some sort of sexual assault, and you're going to lock him into a converted supermax facility in Arcadia where he may never get out. He will get out once the defense has established that at least one doctor says he no longer meets criteria. And even then, there has to be another judge trial on it before he can be released. Taking someone who is about to finish their sentence and locking them up again, potentially for the rest of their life. That is the level of certitude that is required here. And that's what the state doesn't have, is that level of certitude. The court can review the conflicts between the evidence. Now, the court already ruled that we raised a prima facie case, and the state now has to rebut that again by clear and convincing evidence. So what is the evidence? You've got the hearing testimony on the prima facie stage by the defendant, and then you've got a 3-hour video statement. The state wants to parse out every difference between those two. Keep in mind that that video statement was 3 years ago. Keep in mind also that it was made while he was still under the stress of the event. The state says, well, in that video statement, he said it was the left hand. Look at the video statement. That's actually not what he says. There's a point where he gets up and he demonstrates it. And when he gets up and he demonstrates it, at first he demonstrates pulling on it with the right hand, and then he demonstrates it with the left. The two officers are standing in front of him, one of them pretending to be Tracy, the other one pretending to be Mr. McCombs. And here's the other thing significant. The officer that's pretending to be McCombs is standing just behind Tracy. He's not standing arm's length away, as the medical examiner simply postulated, had no basis for that conclusion, but simply postulated that. He's standing right behind him, and Ronnie tries with one hand and then with the other, and then tells the officers, I don't remember. Let's talk about the medical examiner's testimony for a little bit. And here's where I'm headed with this, is the medical examiner testified it was definitely at least 2 feet away. Minimum 2 feet. She thought probably 4 feet. The state's PowerPoint says 3. But she testified she thought 4 feet. And that's how we got up into this situation where I'm demonstrating by grabbing this podium, and she's saying, well, you know, his hand's on her, so I'm figuring he's 4 feet back. But remember Tracy's testimony. Tracy demonstrated. And she's demonstrated the same way, that he took his left hand, and with her hand this close to her face, she moves it to the side, demonstrating how he pushed that barrel out of the way. Not out this way and pushed it out of the way, but right close to her face. What else did she testify to? She testified that it was against her forehead. Now, I asked about a stellate wound, largely to get the witness, establish a rapport with the witness, but also a contact wound would have had different characteristics. And this was not a contact wound, but it was at least 2 feet away, much closer than the 4 inches, maybe as much as 6 inches that Tracy is demonstrating when she takes her left hand and pushes her hand in front of her face as though she's, with the back of her hand, moving the barrel away. We know it wasn't 4 feet away. We know it wasn't 4 feet away because every single person who was there, which is Tracy and Ronnie, both testified much closer distances. Tracy, by her demonstration and testimony about it being against her forehead, is essentially saying that it's within a hand's breadth, maybe 6 inches, maybe a little bit more, but certainly not 2 feet away, because that's not the motion that she made. Ronnie is testifying that McCombs saw his opportunity, grabbed the barrel, and pulled it up and away, trying to take the gun away from him. And that is what caused his thumb to slip off of the hammer. Remember, he was using that as a safety, and the trigger to be pulled, as really the gun is pulled against his trigger finger. And that gives us the consistent wound. From a distance of 2 feet, because it's still at arm's length from Mr. McCombs. Now, we are having to speculate a little bit on the 2 feet because his arms were never measured. I asked her about that, and that's why I asked her about that. Again, there is some difference in detail between the videotaped interrogation and his testimony in court, but that's easily explained by the 3 years' time that's passed between the two, and the fact that when he was talking with the officers, that was immediately after it happened. Also look at the timestamp. This is not, I asked earlier about body cam footage and the use of Zulu time. But this is a surveillance footage. There's no indication on there about Zulu, all right? Looks like it's from around midnight to or from around 11 p.m. to just after midnight. The arrest is just after midnight, according to the video. One of the things that the court instructs a jury in determining what to believe is, does the evidence fit with the other testimony and the other evidence in the case? None of the evidence 4 feet fits with any of the testimony. But the 2 feet that it has to be, that she's certain of, that fits with Ronald's testimony. With Mr. McCombs reaching forward, grabbing the gun, and trying to yank it up and away. State argues that it's vengeance, not fear, because Ronnie referred to the gun as being his fear factor. I think it's obvious what Ronnie is saying is this what he's using to try to get them to not come forward, to not hurt him. He's trying to create fear in them to keep them from doing that. See, I've got a gun. And that's, the state described it in their questioning as aggravated assault. It's not aggravated assault. The Harris case shows that simply showing that you have a gun does not create an aggravated assault. He testified that he cocked it because they were still coming forward, that they walked him down the hall. Now, you don't get to see the whole video. You don't get to see the whole officer's body cam. The state hasn't shown that to you. They show that the porch, when the first officers come out, that the porch is clear, but they're not showing what else is in the house. They're not showing the trash that was in the house. Jury's instructed that they can find reasonable doubt, in this case, a lack of clear and convincing evidence from conflicts in the evidence, or a lack of evidence. And that would be a lack of evidence. The hutch being broken has been explained from the beginning. The testimony consistently has been that the fishing line was tied to the hutch. And Ronnie testified that when they yanked the door open, that's what broke the door on the hutch, the glass door. I'm just skipping through the parts I've already talked about, Judge. The question about brandishing the firearm isn't really the issue. He's allowed to show that he has a firearm to try to get these people to leave his house. The state argued that what Ronnie testified about, and this goes back to what I was saying before about it being both an objective and a subjective standard. People who are acting in self-defense, a reasonable person doesn't make that decision solely upon a snapshot of what's in front of them. Battered women syndrome certainly showed that not to be true. The whole point of battered women syndrome is that after a woman's been beaten a few times, she learns to pick up on subtle clues that tell her she's going to get a good beating that the rest of us wouldn't pick up on. Whether he has a drink before he changes his clothes, how he puts the briefcase down. These are all things that she's used to. They mean something to her. So he's allowed to take into account the incidents before. He testified at the hearing about the acts and threats of violence that had been made to him. He told the officers about the acts and threats of violence that had been made towards him that night. That's consistent. And he is allowed to take into account information that he's gotten even from other sources. If they formed a basis for his decision, if they formed the subjective of putting him in fear, he's allowed to rely on that. The question is, not whether an objective person with no knowledge of the history between these two would look at a wife coming in the house and see fear. It's whether an objective person with all the same information that he had would have come to that conclusion. The state's asking you to look at it in isolation, and you can't, because the objective man standard doesn't look at it in isolation. The juror, being the classic reasonable man, is allowed to look at it with the same information that the defendant had. They don't have to come to the same conclusion, but they just have to decide whether or not that conclusion was reasonable under all of the circumstances and all of the facts known to the defendant. State also argued that his state of mind was hearsay, and I'm thinking I must have misunderstood where they were going with that. His state of mind is not hearsay. If someone else were testifying about what he said his state of mind was, that would be hearsay if it was used for the proof of the matter asserted. If it was used simply to show a prior consistent statement, that wouldn't be hearsay. Now, the state references in their PowerPoint and referenced at the original hearing, and again referenced today, this idea that the statute is poorly drafted, and so we have to rely on the courts to fix it. Unfortunately, the courts can't do that. Your Honor can't do that. Your Honor can't fashion a rule today that ignores a portion of the statute that we think was poorly considered, poorly drafted, just a bad idea maybe. The court stuck with the statute that it has. It's for the legislature to fix it. And the case law cited by all of us comes to that conclusion. And originally, the defendant in these cases had to prove the case by a preponderance of the evidence, had to prove that prima facie case by a preponderance of the evidence. Legislature came back and fixed it. They made it even easier on defendants. The clear purpose of this statute, and if you go back and you look in 790, well, I don't guess it's in 790, but the legislative intent is announced. Well, in 790, it's announced about the free use of firearms for the purpose of self-defense and for lawful purposes. This is designed to be remedial in the sense that allowing people to protect themselves through the use of firearms and not to be subjected to prosecution for having done so, at least under certain circumstances. And one of those circumstances has to do with when you're in your own home and somebody breaks in, you're allowed to assume that they mean you harm and that you're facing deadly force. Now, what did Ronnie have to go on besides the benefit of that statute? Years of abuse from the wife, physical threats, threats to have other people harm him, Joe's actions that night, the fact that Ronnie was told, and Tracy substantiated that they were told basically the same thing, to leave. And she decided to come up and get clothes. So here he is, he's in the house, he's secured the place was ransacked earlier. The police at that point have been out actually 3 times. Once was the welfare check, then followed by after he got home and found the place trashed. And by the way, if there was no damage to anything, why are they having a discussion about community property and that Tracy can damage her property? There'd be no need to. It doesn't make any sense unless there'd been damage. It might not be visible on the pictures that were admitted, but it seems pretty clear that there was damage. So he comes home, he finds all this, he calls the cops come out there. Tracy comes out while he's making a phone call trying to get a hold of his dad. He sees them as he comes back, and Tracy's already been up to the house and called law enforcement. And Ronnie has the conversation, says, "You don't need to be here, Joe. You're in the wrong place." "No, I'm not." And he testifies about leaning about the car, and he testifies later about when Joe comes in, Joe bowing up. So he goes back, he waits on the police. The police don't smell any bleach. Now later, after the shooting, crime scene comes out and they smell bleach, and Ronnie testified he used bleach to clean up after the police had come out the first time. He's cleaning up, he's straightening out the place, and now we've got stuff to be thrown away out on the porch. Makes sense. So after this officer comes out and says, "You get a good night's sleep," they're leaving. The door gets yanked open. He testified about the long history. He testified about the drug abuse. He testified about Tracy's threats. He testified that he was afraid that one of those guys had come in. Somebody was maybe just coming in to rob him. And so he arms himself. And the statute allows him to do that. And allows him to assume anybody coming in means him harm. And he testified, and it's uncontroverted, that he said several times for them to leave, and that they kept coming on him. Judge, this is not a situation where someone calls up and invites the ex to come by and then kills them when they come through the door because they want to kill the ex and they want to be able to argue stand your ground. To the extent that the statute could facilitate something like that, that's for the legislature to fix, not the courts. That's the legislature's prerogative. It's their job. It's not the court's job to try to fix the statute. If the constitutionality of the statute is under question, then the court has to interpret the statute in a way to preserve the constitutionality of the statute. But other than that, the court doesn't get to legislate from the bench. So, with this imperfect statute, as it stands, as the case law stands, as I say statutes, it actually involves two separate statutes. There's the separate statute that's cited in my motion dealing with when you're at home and somebody breaks in and your presumptions that you're allowed. Again, we don't have to prove anything at this point, but the state is not able to prove by clear and convincing evidence that Ronnie was not afraid or that it was unreasonable for Ronnie to be afraid given all the facts and circumstances available to Ronnie.
Sandler, rebuttal.
Your Honor, the defense completely misconstrues what the state said about the law. The state wants the court to follow the law. The state never said it wants this court to make the law. The state said this is a rapidly developing area of the law in which we are just now getting all of the prongs and the things, the guidance that the courts have. And the guidance that this court has, the rapidly developing area of the law, a great deal of it comes from the first DCA, and it is incredibly instructive in this case. Because if the court looks to the Garcia case, that is a case where there was somebody who is actually trespassing, which is absolutely not what Joe McCombs was doing in this case, because he came in with Tracy Smith. And if the court looks at the statutes for trespassing, the court will see that you can infer from the circumstances that somebody is an invited guest. And the defense is under the completely misguided notion that Ronald Norris had the right to arm himself against Tracy Smith. He did not, because that is her home too. This is not a burglary. To characterize this as a burglary flies in the face of the law. That is her home too. She had the right to come in, absolute right to come in, to get her things. Whether it was a good idea with the tensions or not, that doesn't matter. She had the right to come in. She has the right to bring in anyone she wants to bring into that house. And at that point in time, it was Joe McCombs. And he did not do anything to Ronald Norris except stay there. He stood there to protect Tracy Smith. That's all he did. That is uncontroverted. And he ended up getting shot in the head because he was there to protect her because of the tensions between the two of them. So for him to say, I have the right to shoot somebody who is an invited guest in my home, it doesn't matter that he wanted him to leave. It matters that he was an invited guest of Tracy Smith, and that's where we circle right back to Garcia. Because in that case, the court found that the victim in the case, victim in quotation marks, used excessive force on Garcia to get him out of the house. And that's where that case becomes incredibly instructive here. And in that case, Garcia used force, and that's where we get to Mr. McCombs. Did he have the right, even if a gun's in his face, to push it out? He absolutely did. Because there was testimony from Tracy Smith. She didn't even believe that the gun was functional. So why would she be scared to come into the house? And then he comes out with this gun pointed towards them. How are they supposed to react? Are they supposed to run out just because he wants them to, or is she supposed to get her clothes, her stuff? That's what she's trying to do. They've got guns in their faces. This isn't something that people have happen to them every day. There isn't a normal and prescribed way to react to a gun being pointed at you. So this is not a burglary, and it is disingenuous to call this a burglary. It absolutely is. That is an excuse of an angry man, a vengeful man, who committed a murder. He's not protecting himself. There is a difference between anger and fear. This is a case of anger, not fear. And it's very clear in the video because he spends approximately 3 hours complaining about Tracy Smith. He didn't shoot Tracy Smith. He shot Joe McCombs. And the standard the court has to look at is, was an objectively reasonable person shoot Joe McCombs, not Tracy Smith. The medical examiner's testimony, Victoria Kipker's testimony, all of that is objective. These are opinions based on science and not conjecture. And that alone is competent and substantial evidence that meets our clear and convincing burden. What this is consistent with is the defendant taking a step back to take a shot. That is what the evidence is consistent with. What this is consistent with is a man acting in anger, not fear. The state is asking the court after our briefing to deny this motion. Thank you.
Anything else that we need to discuss today? Are we all comfortable with the, briefing schedule that we've come up with? If I could, once y'all receive the transcript, if y'all could send a courtesy copy to my office just to make sure I can use that. Sure. I mean, I've got access to everything, but not the transcript. And once y'all have it, I'll get it. I believe we're still set for February 24th for our next pretrial date. Obviously, if something comes up that needs to be addressed before that, I certainly intend to have a written order for y'all before that, assuming everything goes well with our schedule. Unless there's something else, Ms. Sandler, looks like you're...
Just for the record here, there's been no offer, just so that it is very clear for the record. There's been no offer made to Mr. Norris. He rejected an open slaughter at one point of time, but the state has no offer for Mr. Norris.
Okay, Mr. Williams, anything you want to say about that?
Judge, they're not required to make an offer. I'll discuss with my client. If my client wants to make an offer to them, we'll make that offer. But at this point, it looks like it's just going to have to be a trial.
Okay. Well, let me just put this out there just to make sure that it's clear. If I've given any indication in some way that I'm going to be ruling or what I think should happen, I certainly would make sure that that wasn't my intent. So I'm just going to say this to Mr. Norris. If you think a head nod of mine or a shake or something like that may have given you some sort of clue as to what my thoughts are on the case, especially when it comes to what charges and plea bargains, certainly don't take that as anything that I intended. I just want to make sure that's clear. We try to be as stoic as possible up here, but sometimes things just get said or that the human mind just reacts to. So I just want to make sure that whatever y'all decide on your plea agreements or not has nothing to do with the court. I haven't been invited into that situation and don't ask to be.
The state's just putting it on the record because there was recently a case in the south end of the county where plea offer resulted in $38.50. So we just want to make sure that's very clear for appellate purposes.
Okay. Thank you. All right. Anything else?
Not from the defense, Judge.
Not from the state, Your Honor.
All right. Then we'll be adjourned. Thank you.